Right, hello everyone, and thank you for joining us at this webinar. My name is Sarah Cox, a Director at WSC Group. We've asked along James Whiley from Hall&Wilcox today to talk to us about updating our estate planning matters, and he will take us through the issues that everyone needs to be aware of. So thank you, James.
Thank you, Sarah, and thank you to everyone who's attending this webinar. So I'm a special counsel at Hall&Wilcox Lawyers, and I specialise in estate and succession planning. And we're often asked by individuals, why do I need a will, or why can't I go to the post office to do a will? Won't the law just work out what happens with my estate when something happens to me? Or why do I need to update things if I did it 10 years ago? Isn't that fine? So what the purpose of today's webinar is just to explain in more detail regarding, first of all, why do you need to prepare or update your estate plan, but also some common reasons or triggers to look at doing that to help you work out whether or not you need to do so. So please ask any questions as well. But just a first point to add, so this is intended to be just general comments rather than specific advice. There's a disclaimer here. So if you do need advice regarding this, you should seek specialist advice, whether that be from ourselves at Hall&Wilcox or another lawyer, to ensure that your estate plan is managed in accordance with your intentions. And I'll move on to the next slide, which explains some of the reasons why it's important to get this properly looked at as well. So why is it important to either prepare or update your estate planning? So you've worked hard all your life, and you may still be doing so, building up wealth, for example, through property investment. But if you don't get your estate planning in order, potentially all your hard-earned wealth can be lost or at least reduced anyway. So first of all, your intentions may not be achieved. So the intestacy rules will determine what happens to your wealth if you die without a will. Particularly in the case of second or third marriages, these can end up with your wealth passing to an unintended beneficiary. So it's very important that you have a will to deal with these issues. The other issue is if it's not looked at properly, there may be costly and divisive disputes between the beneficiaries of your estate. So commonly we see what are called family provision claims, which is where, say for example, one of your children isn't happy with what they've received, or if it's a second marriage, that's even more common to have disputes there. And such disputes not only are very divisive for the family and push family members further apart, they're very, very costly and time-consuming. So when a case goes to court, you're often looking at tens of thousands, if not hundreds of thousands of dollars to deal with that. But if you'd actually dealt with your estate planning properly and tried to address those disputes, then those could potentially have been avoided. The other issue is, even if there's not a dispute, if your estate planning isn't dealt with properly, there may be delays and extra cost in administering your estate. So we were dealing with a case recently where the deceased was actually a handwriting expert for the police. So he had beautiful handwriting, but he'd actually written his own will. He's a pretty intelligent guy, but unfortunately it hadn't been executed properly, and he hadn't properly appointed an executor. So the family had to go through a very time-consuming process to get that sorted, and it cost in excess of $10,000 to actually get that through court and admitted in what's called probate, which is where your will is actually authorised by the court. Even if those issues don't come up, there is a potential of missing out on tax and asset protection benefits. So where we're looking at individuals who've built up wealth, often instead of passing your estate to a beneficiary, say for example your children, outright, we do that through what are called testamentary trusts, and these have significant asset protection benefits for your surviving family, but also tax benefits as well, which you wouldn't have if you left your estate to someone outright. So all that's making things slightly more complicated up front. It's a big benefit for your surviving family. There's also tax as well to consider. So this can be an issue where different assets have different tax liabilities. And David Shaw at WSC and his team will be very well placed to advise you regarding that, working out how to deal with that. So looking at some of the trends and why it's important as well, because these reflect on this. So increased wealth. So if we've been looking at people, 10 or 20 years ago, the average person wasn't as wealthy as they are now, and that's particularly the case in Sydney and Melbourne, for example, where normal houses are worth in excess of $1 million. So even people who didn't think themselves particularly wealthy are now pretty wealthy, including their superannuation as well. Because partly of the property changes, it's become quite common to assist your children, for example, helping with a property purchase or a business, and also looking at helping elderly parents, say, for example, downsize and the concept of a granny flat. But all of these have implications in terms of your estate planning, and say, for example, assisting children, often it's best to do that through a formal documented loan than giving money to them outright, because if that child then gets into a relationship problem, or they have money problems, then at least that money is protected. This then moves on to the next point: relationship breakdown in second marriages, which is becoming increasingly the norm, and that certainly complicates your estate planning and the potential for disputes. And finally, incapacity. So given that people are living a lot longer these days, things like Alzheimer's and dementia are becoming increasingly the norm. So it's important that not only do you have a will, but you also have documents to deal with your incapacity. So in New South Wales, that's called an enduring power of attorney for financial decisions. And then you also have what's called an appointment of enduring guardian for medical and lifestyle decisions, so things like where you will live, going to a home, up to ultimately turning off life support. When do you actually want to consider this? So we recognise, it's human nature to want to put this off, because people don't like thinking of their own mortality. It's a difficult thing to think about. But what we find is when people have actually gone through this process and considered it properly, it takes a lot of pressure off thinking about this, and they know they've got their plans in order. So even when people have actually got their estate plan up to date, when do you actually need to consider this again, though? Because it's not just a thing to put in the drawer and forget about. So we'd say even if there aren't any changes, just to have a quick look at it every 3 to 5 years to check if anything needs to be changed. When there's significant changes in terms of legislation and case law from the courts. So a big change this year is the Superannuation Changes and how this affects people's estate planning strategies. So these are going to come into force in July this year, and it particularly affects people in second marriages and where they've got significant balances in excess of $1.6 million in their super funds. And finally, there's when there's a significant change in circumstances, which I'll move on to now discuss. So the next slide just explains some common reasons why you need to either prepare or update your estate plan. I'll go through these now. So the first one is having children or family changes. So this can be having a new child. So does your actual will cover this new child? If it names your children specifically, it may not actually cover that child. Or if one of your children becomes an adult, what does that mean? So it might be appropriate to appoint them to the role of executor or one of your attorneys, and the role of guardian of their guardian anyway, if something happened to them, to both of you, and you weren't around, then ceases. Other common factors are if something happens to one of your children. So this could be a physical or mental health issue, which meant you needed to better structure your wealth in terms of how it's left to them. So you may want to put a special trust in there. But it can be other issues too. So it can be things like one of your children getting into money problems, because you don't want to leave money to a bankrupt child, because that will just go to their trustee in bankruptcy. Or it can be if one of your children is actually getting married and you're a bit unsure about the relationship, or if they're in another relationship, you don't really want to give money to them outright, because then that may be lost. So you can look at putting in place a trust for them instead. I mentioned before a child purchasing a home or starting a business, so that was the idea of lending money to them rather than giving it to them outright to try and protect that if something happens to them. And given that the blended family and divorce and relationship breakdowns increasingly becoming the norm, the kind of disputes we see around that are also becoming the norm. So you can actually do things around that to try and you can't prevent them making a claim, a child in particular, but if a claim is made, you can try and make it less likely to succeed. So you can do things like setting out your reasons why you've treated your children differently or stepchildren differently in a formal legal document, and then if a claim is made, that can then be used as evidence in such a claim. But if you don't have that kind of reasoning or take other steps, then the chances of a dispute being successful are greater than if you looked at that properly. Looking at relationships here, so this covers personal, also things like businesses. So marriage and divorce, depending on the state, will usually void or partially void a will. If you're entering into a new relationship, or if you're having a relationship problem, say with someone, existing spouse, you may want to put in place steps there to try and protect in case you die, and you want to try and protect it for your children. So things like putting in place trusts there, and the same applies to your children. Threats to your wealth, and also those are the beneficiaries. So if you've started a new business or gone to a certain job that means you're more likely to be sued or make bankrupt, then again it's a reason to look at your estate planning, because there are structures you can look at to try and protect that, as with any of your family. And the final one, changed intentions because of relationships with individuals. So this can be, who do you appoint as your executor? Is that person still the right person for the job? Or you may want to change how you benefit your beneficiaries in your will by changing the amounts or putting in place protections around that. The next point, which I covered before, was illness in terms of children, but this can cover your spouse. So if someone is really ill, for example, severely disabled, you can put in place what's called a special disability trust there, which has special tax advantages. Or if there's been a death in the family, which means that individual who's named in your will is no longer there, then it's another trigger point to look at updating your estate plan. Superannuation is a big one, like I mentioned at the moment. The issue here is if you've got more than 1.6 million in super in particular, then the excess may potentially have to come out of super on your death, and the issue then is, where does that go to? So you may want to go through the terms of your will. If you've in a second or third marriage and you're using super to plan for looking after your spouse from the second marriage, then you'll need to look at the planning around that to see if there's still enough there for them, because they're not able to keep all the money in super. Even if you're not affected by that, though, it's important to work out what happens to your super on your death, because it doesn't form part of your estate for your will to deal with. But what you can do is put in place what's called a binding death benefit nomination, and this just ensures that your super is dealt with in accordance with your intentions. The next big trigger is inheritance or a change in wealth. Say, for example, you've inherited a lot of money. You may want to look at testamentary trusts there, because it's more beneficial to have those there. Conversely, if you've lost wealth or you've taken on a significant debt or other liability, you need to look at its effect on your estate planning. Or if you've gifted away, say, for example, shares you've owned that were going to go to one of your children, or a property that was named in the will, then that gift will fail. So you may want to look at things because of that. Moving on to international issues. So we're seeing it's increasingly common for people to own assets abroad, whether that's someone who's moved here or who's bought a holiday home somewhere. And often it's the case that you will need a will to deal with the asset in a separate will to deal with the asset in the other country. And those wills need to make sure they don't conflict. So you'd have an Australian will and a will to deal with the will in that local country. And then there's also tax issues to consider in respect to, say, for example, inheritance tax in that other country, and also the Australian issues. Another thing that, children living abroad or marrying non-Australians, and that can bring in tax issues. For example, the US is very problematic there in terms of they have estate taxes that are based on citizenship, and it's very hard to get out of them. But the UK also has similar issues with inheritance tax, so you need to source specialist advice there in respect to that. Next point is investment changes. So as I mentioned before, superannuation doesn't form part of your estate. So if you set up a super fund or you've got a standard industry fund, it's important that that's looked at. It's increasingly common for people to look at setting up family trusts because they're beneficial from a tax and asset protection perspective, but those trusts don't actually form part of your estate for your will to deal with. You need to look at the terms of that trust and work out how does control of that trust pass, and it's often the case you need to deal with a separate document to deal with the passing of that control, and otherwise your will, it may not be effective if it's just done through your will. Also establishing a business or looking to retire or pass on a business to the next generation. So that's a big issue there in terms of if you've got children, for example, are they interested in taking on the business? There's a lot of business succession issues there. If you're looking at going to business with a third party, we'd usually advise that that's documented through what's called a buy-sell deed. The reasoning being is that if something was to happen to you, you've got to ask yourself, do the survivors want to be on the board with your spouse? And I've never heard anyone say that they want their spouse to be in that situation because they don't understand the business, and neither do the other co-owners want that situation to happen. So they're the kind of things to look at there, and your estate plan needs to work with that. The next thing, which is particularly relevant for property investors, is buying and selling real estate. So how is that asset going to be owned? If it's owned as what's called joint tenants, then, which is the common way to own real estate, then on the death of one of you, that passes automatically to the surviving joint tenant outside of the terms of their will. But what can sometimes be better from an asset protection perspective is to have it as what's called tenants in common. Still would remain same ownership in terms of percentages, but if something happens to one of you, their share can then go through the will, and then you can put in place asset protection there. Finance is a big issue as well to consider there. So if something happens to one of you, will the survivors still be able to maintain the payments on that property? So you may want to look at having some form of insurance there, and WSC will be able to assist in sourcing that kind of insurance with their advisors there. And finally, just some other improvements to look at with wills. So what we often see is people who are in at-risk positions, so say a doctor or a lawyer, and they've structured their wealth in their lifetime so that their spouse, for example, owns all the assets and they don't own any assets in their own name. So this is excellent from an asset protection perspective, because if they're sued by someone, then they're protected. The problem is that their will often is a simple will where they pass everything to each other. So say, for example, the wife, or it could be a wife or husband, whatever, dies who owns all the assets, and they pass everything to the person who's in the at-risk position. So that then undoes all the asset protection which they placed during their lifetime. So instead of doing that, you need to look at it carefully. It may be appropriate to have trusts there in the will instead. And it's also very common to have older wills that don't have testamentary trusts in there. So again, whether a testamentary trust is appropriate depends on your own personal circumstances, the level of wealth, and what you want to do with it. But we normally see clients with a reasonable amount of wealth actually want these in their wills because of the asset protection advantages. It's not an asset which you own, so if you're sued or made bankrupt, it's protected. Sorry, if one of your beneficiaries is, and it has a limited amount of asset protection in relation to relationship breakdowns. But the big one with tax is if you've got, say, minor children or grandchildren, there's very big tax advantages there compared to owning an asset in someone's own name. So you would effectively end up saving a lot of tax there. So that brings to an end in terms of triggers to prepare or update your estate plan. I've just quickly included some further slides here in terms of how you go about doing that if you wanted assistance from ourselves at Hall&Wilcox and WSC. So we would work very closely with your advisors at WSC who know all about you. And the purpose of the next slide is just to explain the process for preparing or updating your estate planning. So the first slide here just recognises why it's important to deal with your estate planning, which I've gone through carefully now. but also reflecting the fact it doesn't need to be a time-consuming or complicated process. We've made this as straightforward as possible. This just next slide just documents where we're experienced in this area. So we wouldn't recommend, particularly where you have a reasonable level of wealth, going, for example, to do a post office will, or we sometimes find that things like if you're purchasing a property or conveyancer, also they do a will free of charge, but they don't understand the issues. They're not experts usually in estate planning, so it's important that whoever you go to, whether that be ourselves or another lawyers, understands the issues properly here. And finally, this just documents our process in terms of this. So we have a clear process in terms of how this is done and fixed fees for the work. So if you wanted advice, all you would do is to arrange an initial no obligation meeting at which we can discuss these issues and your strategy further, and then get a fee on the back of that. And then there's a clear process for that as well in terms of the steps. So you know what you can expect will happen, and there could be time frames built around that as well, depending on how quickly you want that sorted. So thank you very much for attending today's webinar. You can contact us through your contacts at WSC, and they'll be able to put you in touch with ourselves if you want to discuss your estate planning further. And there's also an option here in terms of contacting us directly using the pair Hall&Wilcox email address, and then we liaise with your advisors at WSC. Thank you very much, and goodbye.